The purpose of this podcast is to serve as a quick guide to objections in the courtroom. Okay, so why? Why is this important? The judge's decision in a court case is based on the court record. Objecting to evidence presented in court is the legal way to keep it out of the court record. And I'm about to share with you some of the most common objections. Okay, that was the why. Now let's talk about the how. As soon as you hear the other party introduce evidence or ask a question of a witness that you want to object to, you have to say objection. Even if the judge rules against you, it's important to have that objection in the court record in case you later file an appeal. Okay, so let's talk about the different types of objections. One of the most common objections is relevance. I would say objection, relevance. So when would I want to use this objection? This is when evidence is irrelevant to the case, meaning it has nothing to do with the issue the judge is ruling on. For example, asking about sexual partners in a restraining order case. Okay? Another major objection that I use quite often is objection leading question. When a question is asked on direct examination that leads a witness to a particular answer, usually yes or no. For example, I was with you on X date, right? Now that would be a leading question, but they are allowed for cross-examination. So let me explain. When I'm in the courtroom and a witness is being called by their attorney, and the attorney starts asking the witness questions that can typically only be answered by yes or no, then I would say objection leading on direct examination, because that is the direct examination of the witness. So I just say objection leading on direct, and the judge knows what I'm talking about. Now sometimes the judge will allow it or not allow it, or if I myself call my own witness and I ask them a question that can only be answered by yes, no, and the opposing counsel may or may not object, saying objection leading on direct, I'll usually try to assure the judge that I am demonstrating the importance of why I need to ask this question. And that goes with also any objections to relevance. If I ask a witness a question and the opposing counsel says objection relevance, then that's when I'll tell the judge, well, I'm about to demonstrate why it is relevant, so please let me ask the question. And usually the judge does, but sometimes the judge will not allow you. Okay, next big objection is objection compound question. That is usually when two or more questions are combined into one. For example, why did you go into the house and who was there? So you're asking two questions in one. That's compound. Now, I mean, it is an objection, but I mean, we have a lot of information to get through at the hearing. I mean, sometimes the judge might allow within reason. Okay, next objection is objection argumentative. This is when a question is asked to harass or argue with the witness rather than to get information. And sometimes it does happen. Okay, next objection is objection asked and answered. And oh my gosh, I use this a lot. That is when the other party keeps asking a question of the witness, trying to get a different answer or to emphasize the answers provided. So usually I'll say objection, asked and answered. And the opposing counsel might get frustrated because they're trying to get the answer that they want to hear and they're not able to, so they try to ask the same question in different ways, and that's when I come and say objection asked and answered. Okay, next one is no foundation laid. Some testimony or evidence requires background information to explain it, known as laying a foundation. For example, to introduce a voice recording, the witness must first testify to how they recognize the voices in the recording. Another popular one is objection non-responsive. That is when a witness responds to a question with unrelated information that you don't want in the court record. Now that's very common. I ask a very simple, direct question, and they do not want to answer it. Best thing to do is make sure you have some evidence ready to go, just in case they do answer the question and they're not being truthful. Okay, speculation. Next one is objection, speculation. That is when a witness can't answer the question without guessing or assuming facts that they don't actually know. So usually if you're asking a witness about something that, something that could happen in the future, typically that's speculation. Okay? Next one is objection, opinion. That is when a witness testifies about their opinion as opposed to facts they have firsthand knowledge of. Only an expert witness can provide their opinion. Okay? Hearsay is the final one, and it's very common. That is an out-of-court statement offered to prove the truth of the matter asserted. The most common example is trying to testify about what someone else who is not a party to the case said in the past. And yes, this is actually a very common objection. I use it when the witness starts to try to repeat what someone else said, and that person's not present in the courtroom to be cross-examined. So it's not fair to put words in their mouth if they're not in the room to defend themselves. So again, hearsay is an out-of-court statement offered to prove the truth of the matter asserted. Now, the interesting thing is you can actually technically bring in certain out-of-court statements if it's not being used to prove the truth of the matter asserted. Maybe you're bringing an out-of-court statement to show that the person spoke English versus another language, and you're not bringing it in for the truth of what they are saying, just the fact that they were maybe speaking in a loud voice, a light voice, or speaking in English versus another language. Okay, those are some of the most common objections in the courtroom, and this was your quick guide, citationwomenslaw.org. Thank you for listening.